This case is a perfect storm of confidence, misinformation, and courtroom reality colliding at full speed. We're not just watching a defendant who thinks he can outsmart the system. We're watching someone who genuinely believes the law does not apply to him, while simultaneously demanding the protections of that same law. That contradiction is the heartbeat of this entire case. Mr. Valentine isn't just refusing counsel. He's rejecting the very framework that gives him rights in the first place. And with a jury trial looming, every misstep he makes now compounds the risk he's facing later. Judge Lynn Toller is doing what experienced judges often do in these situations. She's patient, firm, and meticulous in building a clean record. Every warning she gives him matters. Every clarification she makes is designed to protect the integrity of the proceedings and, frankly, to protect him from himself. Meanwhile, the prosecution isn't playing games. They're laying out a history of failures to appear, prior DUI allegations, and public safety risks that make this more than just courtroom theatrics. So as you watch this unfold, keep one question in mind. Is this about constitutional rights, or is it about refusing accountability? Because what starts as a performance quickly turns into real consequences when the judge starts talking about bail, custody, and public safety. And trust me, this is only the warm-up.
Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
Mr.
had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests.
All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
This is where courtroom fantasy meets hard math. Bail isn't punishment, it's leverage. And when the judge talks about $15,000 on each case, she's sending a very clear message. Your past behavior matters. Failures to appear, prior warrants, and DUI allegations aren't abstract concepts. They directly inform whether someone is considered a danger to the community or a flight risk. Judge Toller isn't speculating here. She's grounding her decision in documented history. What's striking is how Mr. Valentine frames accountability as persecution. Confusion about court dates, clerical errors, unanswered letters. None of that negates the court's authority or the requirement to appear when ordered. And when he pivots into sovereign citizen language, claiming he's not a person, rejecting contracts, invoking imaginary legal doctrines, he's not strengthening his position. He's weakening it. Here's the uncomfortable truth. Self-representation doesn't earn you leniency. The court doesn't lower standards because you opt out of counsel. In fact, the opposite happens. You're now fully responsible for knowing the law you insist doesn't apply to you. So ask yourself, if your freedom was on the line, would you really want to be your own attorney?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as, what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
Well, Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do it.
I am not pro se. I'm a seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated?
This exchange perfectly captures why sovereign citizen arguments collapse under scrutiny. Jurisdiction isn't optional, and it's not something a defendant gets to vote on. Judge Lynn Toller makes this clear without theatrics. This is Thurston County District Court, State of Washington, and yes, it has authority over him. Period. The moment Mr. Valentine entered that courtroom, jurisdiction was already established by statute, geography, and alleged conduct. The not a person argument is especially damaging. Legal rights don't float in the air, they attach to legal persons. When he tries to argue himself out of personhood, he's effectively undermining every constitutional protection he claims to cherish. Judges don't entertain semantic gymnastics when public safety is involved, and Judge Toller is visibly focused on one thing: keeping the record clean and the community safe. Notice how she doesn't debate philosophy. She redirects to compliance. That's judicial discipline. This isn't a law school seminar. It's a criminal proceeding with real stakes. And every time he refuses to engage on the court's terms, he gives the judge more justification to tighten conditions rather than relax them.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the
you
facts,
can
man.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
An attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm of sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel. We can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So, Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation.
Okay.
I have advised
well,
him.
Okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treat it as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with 2 cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
Do you have any questions for me?
That was
Other
the
than
question.
that? No, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
People of
just
special appearance.
no. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you is why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you. Folks, I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to.
Well, I object to that. You're not allowing me.
We'll note your objection.
We need to get you unmuted.
Yes, ma'am.
All right. So there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me. And the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
That's not part of the motions I have here that were
There
filed.
was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was.
Yeah, I objected to his denial of those motions as well because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th, and that was October 21st. I have a request to release you and your request, let me get back to your court to dismiss these charges, motion to release you, and that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So, just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading, one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
I was stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. Get it.
That's the state's understanding as well, Your Honor.
All right. I've had some time here to review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward, and the docket and your pleadings. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th of 2024, Judge Buckley or that the state provided Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
This is where self-representation quietly becomes the biggest liability in the room. Discovery was provided, documented, delivered, and confirmed on the record. Once that happens, the burden shifts to the defense to demonstrate a real violation, not just dissatisfaction. Judge Toller methodically walks through this because appellate courts care about process, not volume of filings. And she's making sure the process here is airtight. Mr. Valentine's argument isn't really about missing evidence. It's about control. When the evidence doesn't support his narrative, he reframes it as misconduct, ineffective counsel, or constitutional violations. But courts require specificity. Allegations without legal grounding don't trigger sanctions. They trigger denials. That's not bias. That's procedure. What's also telling is how often he conflates legal assistance with legal strategy. Judges do not coach defendants. and Judge Toller makes that boundary crystal clear. Fairness doesn't mean favoritism. The courtroom is neutral ground, and neutrality can feel hostile when you expect validation instead of rulings.
Okay, so a thumb drive that he could view those, a request form for the dash cams, what does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb
All right.
drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The state had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective with the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense. And they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed sui juris because I had my own best interest in mind. And it seems that the public defenders that were appointed to me were not assisting me effectively. And this was creating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of the discovery rules.
Well, I'm not finding there's a basis in your pleadings or what I've heard today to sanction anyone for a violation of discovery. So I'm not going to do that. And now you're also, I mean, I don't know if this was dealt with, but throughout your pleadings, you're concerned about this court, district court having jurisdiction over you. Is that still at issue, sir?
Yes, there was some service issues, as I mentioned before, which for some reason keeps getting ignored. The state served my address knowing well that I was in custody. They didn't serve me the court docket for the last hearing. And that lack of service creates a lack of jurisdiction for the court.
I
There's
disagree.
also
Those are different issues. Go ahead, though. Maybe you've got something else there. What?
Oh, I was just going to say there's also been a number of courtroom violations taking place, which is why the last judge ended up recusing himself. But beyond counsel being ineffective in mounting any defense, they convinced me to give up constitutional rights instead of enforcing any constitutional rights. They lacked to challenge anything that the state was doing. They didn't challenge or attempt to suppress the evidence. They didn't even share the discovery information with me upon my request. And the court also was violating General Rule 43, my personal pronouns, continuing to try to say I'm pro se instead of sui juris, not changing, acknowledging my name or acknowledging my status as an American national. I also submitted a letter from the Washington State Attorney General's office where they're acknowledging my status as an American national. They're acknowledging my fee schedule, where for some reason this court hasn't been acknowledging my pronouns at all.
Okay, so Mr. Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial.
Mm-hmm.
So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance of counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because
We
I'm going
understand
against
that.
the state,
Mhm.
and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records
Yes,
and
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case, of what I was trying to get straight with prosecution, and none of those questions were answered, as far as the legal terminology that we're using.
So what they're charging you with, or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly is being meant by the legal terms being used.
Trying to figure that
For
out.
example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so all right, transcript of past hearings. Something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
Yeah, I
period of
wanted the
time?
communication between previous counsel and the prosecution, the case transcripts, and the bonds on record and oaths of office.
Okay, of the oaths of office of the prosecutor who?
You and the prosecutor, and for the attorneys that I previously had.
Well, for me, you could just go to the auditor, state auditor, or the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office. I don't
Would
find
the
that.
Office of Assigned Counsel can't provide me with that?
You can certainly, yeah, ask them too. Ask them for their people what they have. I can't say.
Okay,
what
yeah.
that-
I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to.
Because even though I'm
Making this
representing
before.
myself, the court is still obligated to provide legal assistance.
The court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial. That would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
When I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
yeah,
I just
well,
don't want anyone speaking for me.
so you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. A lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be represented or deceived into taking someone else's opinion of how to handle things.
Well, you don't get to kind of pick and choose how it's done. We've appointed counsel at one point, and you didn't want to do that. I could potentially, and I can't speak for the Office of Assigned Counsel. You know, they're the executive branch government. I don't run their office. I simply find if someone is indigent or qualifies for public defense and say, yes, they can have one, and then that agency takes over. But at this stage, so
When I was made pro se, that is what Judge Brent Buckley had discussed. He said that I wouldn't have counsel represent me,
yeah.
but that I had legal assistance. And I
So
communicated with the Office of Assigned Counsel. They assigned me someone,
they did?
to help
Okay.
me. So
I didn't know
as
that.
far as I knew, that's what was going on.
All right. Have you talked then? I'm kind of wondering why someone's on here. All right. So since that you need to, have you had contact with that person since
Yes,
that
it's someone with the
appointment?
last name Thomas. I don't have it written down, but yeah, I've called and sent him some emails. I got him from the supervisor.
Mr. O'Connor?
Yeah, Mr. O'Connor,
Okay.
yes. He told me
All right.
someone, I think Alex Thomas or something like that, was
Okay.
someone he referred me to, and I've contacted them, but I haven't got a response back from them.
And when was that?
This was just before I got out of jail, so
Just the end of last month,
yeah.
somewhere around there.
Yeah.
Okay. Or beginning. All right. Well, so, all right. So we're like 10 days to trial. You haven't talked to the attorney that's public defense has provided for legal assistance. And so is that part of why you're
Yes,
not
ma'am.
ready to go? Okay.
Yeah.
Because that makes more sense to me. All right. Well, let me turn to Mr. Abid, who's representing the state on that issue.
State would have no objection to a short set over, Your Honor.
All right. So now, just so you understand, you're asking for a continuance. It's a fair request. I would find what we call good cause for that request. But that would put us into an excluded period under the time for trial rules. And we would set another confirmation date, and we would set it, actually, we'd set a motion date, confirmation date. Let me look at these motions. Motion date, confirmation date, and a jury date. We'd send those to you in the mail. And if you'd like a text message reminder, we'd send you one of those too. And then going to go on the process. And then at that point, then you contact, I would think you would want to contact Mr. O'Connor's office and be sure that you can hook up with the person you need to and discuss all of this with them and then be back. But we're going to set that motion hearing so that we have everything done. Now, you filed everything. You filed a lot of motions. You've got everything filed. State needs to respond, and then the court will hear from both sides and make a decision.
Okay.
All right.
This case ultimately isn't about sovereignty. It's about accountability. Judge Lynn Toller has consistently done what the law requires. She's warned the defendant, protected his rights, ensured discovery was provided, and maintained courtroom order while giving him every opportunity to reconsider his choices. The rulings we've seen on bail, jurisdiction, discovery, and continuances aren't personal. They're procedural, measured, and firmly rooted in public safety and due process. Mr. Valentine's insistence on self-representation, combined with legally unsupported arguments, has placed him in an increasingly precarious position as trial approaches. Courts don't reward defiance. They respond to evidence, compliance, and clarity. And unless something changes dramatically, the jury trial ahead will be about facts, not philosophies. Now, if you found this case as shocking and honestly as fascinating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. These cases matter, and we'll be here breaking them down every step of the way.